Hello, Sofa Squad. How is everybody doing? Let me just come over here and mute this. All right. Okay. How is everybody doing? I hope y'all are well. Y'all, drop a number one if you can hear me in the comment sections. Pretty please, so I know that y'all can hear me. Is what I'm getting at. Good Lord. I mean, come on now. Y'all, drop a number one. Let me mute myself over here. All right, we got ones. Hello, everybody. I do appreciate y'all. First and foremost, as usual, y'all, please welcome Miss Emily to the stage, to the sofa. She is our moderator in chief here. Well, hello. Even little Connor says hello, Emily. Um, she is our wonderful friend, our wonderful human, and I hope you are doing well today, Miss Emily. And Connor says hello to everybody. I hope the Sofa Squad is doing well. Come here. We just got up from a nap, and so it's going to be mega playtime, of course. And he wants his little attention. So I hope y'all are doing well. Obviously, what we're doing today is we're going to be doing the Sarah Boone stream or whatever. I don't know what they're talking about. Probably some of those motions that I put up today. When it comes on, I think it's coming on now, we'll put it up and we'll listen to it and we'll talk about it. And that's it. I hope y'all are doing well. Y'all, if you are anywhere near or whatever, involved in, a victim of whatever the situation with the hurricane that went through, my heart breaks for you. I am sorry. I'm going to put together a list of things that people who I know live in, like Asheville, because that's mostly what I hear about, are saying of reputable places and whatnot. The devastation is horrible. I've not personally been there. Obviously, we're fine here. We're very lucky. We're, a few hours away. But it's just, there's no words for it. No words for it. So yeah. But that's what's been going on here. Oh, thanks, Kate Bush. I appreciate it. Um, and wait, let me get to this other screen here. So yeah, that's what we've been doing. Now I put this, I think, on the Patreon, and also for any Patreon members here, y'all, my thing keeps doing this. The little the group chat that we have going there on my app on the phone, it'll keep coming up and it'll say, uh, "This isn't here anymore." And then it'll come back. I don't know if y'all are having the same issue on there or not, but I don't know. Y'all said you weren't on the thing, but it just did it again a little bit ago, and then it came back again. I don't know. Um, But that's it. So I hope y'all are doing well. But things are going well over here. Like I said, I'm in the Raleigh-Durham Chapel Hill area, so we just got rain. Okay, that was not a big deal at all, right? But yeah, it's bad in Asheville. It's really, really bad. So it's just, I don't know. I'm kind of speechless over it. Okay, so there's that. Couple of different things. First of all, y'all, I went and saw The Substance last night. I'm gonna do, if you follow me, I have the movie review channel. Um, I'm gonna put a review of it on there. I'm working on a review for Oddity. I'll have that posted maybe tomorrow. Um, but I went and saw The Substance. I just got the phone with Derek talking about, because he knows that, like, we're both big horror fans. Oh, thank you, Tender Heart. I appreciate it. And it's your first Super Alive. Well, I'm very honored. I do appreciate it. Um, it was insane, y'all, that movie. It was insane. Okay, so it's coming on. Now, remember, when it comes on, I'll ask you to drop a number one in the comment section so that we can make sure that we hear that. And that's it. And hello, Amy, police wife. Amy, that picture you dropped in the Patreon live chat thing, and I don't know if you just heard me talking about on my app, it keeps going away. That picture you just dropped there of Sarah at the game show thing, 100% it's her. 100%. We have to find that episode. Have to find that episode. Okay, we have to. Okay, side note before this gets started. So I have been watching. I finally sat down. Y'all know that I am a little behind on things when it comes to, like, whatever. So I am just now sitting down to watch Hidden True Crime, Lauren and Dr. John's interview with Stefan Stern's parents. After that, I will watch the visual video that she has of Jen. Y'all, oh my God. most of y'all know who Miss Rubel used in the episode. Okay, so was that episode? Okay, um, most of y'all watch and true crime. If you don't, go look them up. They're amazing. And I'll do like a commentary video, kind of like I do on the documentaries we watch. I'm just making notes, but I want to like catch up on all the stuff from these interviews and stuff like that to just do one big video or whatever. Oh, thanks, Nancy. I appreciate it. Angela, go watch it, but you have to be in the proper headspace. I will say this overall. First of all, Lauren, oh, thank you, Aaron. I appreciate it. Um, Lauren and Dr. John to me are amazing, like hosts or interviewers, however you say it, because they just allow the person or persons, whatever it is they're doing, interviewing, to just speak. You know what I'm saying? And that's what they've done here. They ask a question and just let them talk. They don't interrupt, they don't do anything, they just let them talk, right? And it's fascinating to me. I mean, maybe an hour into it, and please hold. We got the unintentional cup out today. It's one of them. It's one of them. It's just, I would say I see more emotion talking about Madeline than I have from Jen, coming from Stefan's parents. So yeah, it's definitely go check them out. It's amazing. Hey John, how's it going? Sarah's trial is next week allegedly, and we're gonna 100. Oh, hold on, let's go see what's going on here. Hold on, please hold. Okay, so it's just like you can kind of hear the background noise. I'll let it play. Oh wait, this might be going. Hold on, no. Oh, he's worried. Oh, Owens is worried. Oh, y'all. He is what worried. Do y'all know? Okay, do y'all know what? Let me just go mute it again because I don't want it to mess things up over here. Wait, let me see. Okay, Jen is checked out. Yeah, 100%. Hey Shanna, how's it going? Shanna, I got your message on I think Facebook thing you on the Facebook page, and I've got to respond to you. I'm sorry, I know it's been a minute, but I just haven't. But I've read it, and I'm gonna get up with you. I've just been kind of like in a so I haven't told everybody. Well, I told the Patreon stuff today. Um, and hold on, let me go over here. Let me make sure they're not talking. So, in addition to just working all weekend at my regular job and doing all that, we have had puppy drama. And let me go back and mute this. No, 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 we don't want to do that. We just want to mute it. We've had puppy drama over here, and the puppies are okay. Come here. But overnight, maybe starting Friday, Bo William, this is Luke Connor. Come here. Bo William decided he was 100% going to kill Luke Connor. I'm not talking about extra puppy play. I'm talking he was going to kill Luke Connor. And so we basically went into a level of you couldn't keep them together. Okay, I know. So, Matt has his place, I have my place. It's easier to keep them separate over there and everyone be in the same room. Um, but we basically had to keep them separate. They could play through a fence, and I mean, it was like whatever. So, the two dogs are over there. So, long story short, we kind of did that, went back and forth. It became a 24-hour. One has to be over here. We're screeching, we're crying, we don't want to be in the thing. And yeah, they are brothers, they are litter mates. And so I was like, yep, here we go, litter mate syndrome. So, long story short, we got through the weekend because I had to work over in Raleigh. So I stayed over in Raleigh. I came back over here to my place, brought Luke, left the meanie, who they're completely sweet on their own, right? But we left the meanie with a bigger dog so he could kind of get put in his place type thing and get some parenting from them. Um, the gentle one, Luke, came with me to have some one-on-one time. Let me, number one, get him fed up a little bit. He's a little bit smaller and whatnot. So I took Luke to the vet yesterday just to ask him tons of questions about like what do we do, blah 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 blah. Oh, thank you, Emily. Um, and whatnot. They said it's not a lost cause. Do not go down the pipeline yet of like, oh God, we have to rehome one. Oh my gosh, what am I going to do? Um, they were like, do all the things you're doing and bring them together for very controlled playtime. And you basically just need to mama them and let them know we can't do this or whatever. And so I'm praying that by separating them like this and continuing doing their training separate and then bringing them together, all this is going to help the behavioral issues. When they get a few weeks on them, I'm going to get a trainer to come in to work with both of them and then together and whatnot. So that's what's been going on. So it's just been like nonstop. Oh, thank you, Emily. Gifted 10 memberships. That's awesome. Thank you. Um, Yes, the aggression will be checked by your older alpha. That's what we're hoping. Because let me tell you this, Bo 100% is trying to take alpha status of even the older dogs. We're talking a 2 pound Yorkie, okay? Love him to death. K Bush, thank you so much. My two Aussie brothers, 16 months fight to the death. Yeah, if y'all could have seen what happened, it was so scary. Well, come here. Literally, when we put him down, Bo treated, you know how a cat does a bird? That's how Bo treated Luke. And when I say he latched onto him, I'm talking a death grip. Imagine two grown male dogs fighting where you have to grab their jaws, pry them off of each other. That's what his brother was doing to him. And I was like, and the other dogs came around, but you know how dogs will get a pack mentality and be like, oh, it's injured, kill it. I was like, oh my God. So we just reset everything. So, um, we're praying. But Matt sends me videos of Bo and pictures. He's playing, he's curled up with the other dogs, and all the dogs are male. Um, so, yeah, they were very mean to little Lukey Poo. So yes, little Luke has had some one-on-one. Oh, thanks for being a member, Deb. I can't wait to see that. I know, right? Me neither. Um, so that's what's going on. So yeah, it's just been crazy. Um, Carol says I have six month old littermate boxers. I get yeah, and I researched the littermate thing. When I got them, but go on. I know there was issues with their mother. Um, Book Mom says no true grandma sofa things puppers. I know, right? Oh, thanks, Shannon. I'll check that out. Hey, Chrissy, how's it going? Um, yeah, it was so frightening because here's the thing: like when they're together, and each in their like little homes or whatever, I'm talking it was 24 hours of screeching and feeding off each other, and separate them, they were fine. So they definitely need to kind of be separate and become their own person and then come together. You know what I'm saying? And try that. And we're just fortunate to where Matt has his place, I have this place. So I have to go over there Friday. Then we're gonna stay over here because we get stuff done at the house this weekend. Then he's going to take Luke. I'm going to take Bo over here. You see what I'm saying? So it's just going to be back and forth for a little bit. But this is much more maintainable. And we'll see how Luke does over there with the big dogs. And then we'll just do it. Wait, let's see. What's going on over here? Now, so there's that. So, again, nothing's going on. So, Sarah Boone. Let's talk some Sarah. Let's talk some suitcases. Let's talk some Boone. Okay, so Sarah, trial October 7th. This is coming up, okay? Sarah, hey, I know, report. Do we need to get some? Let me grab some toys real quick, y'all. Okay. It's playtime, I know. What about a little shrimp, or a little fishy, or a dinosaur, or a sushi, or a little ball, or a little ball? Um, a goochie, 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 goochie. There you go. So, October 7th, trial coming up. Now, for those who are unfamiliar and whatnot, again, Sarah is standing trial for taking the life of George Torres, her former, now late boyfriend. She got manipulated him into a suitcase, basically let him suffocate in there. Sarah says it was unintentional. Sarah is trying to get her interview thrown out on Miranda rights. Sarah's also trying to get in a glam squad for the trial, and all this stuff is going on. So that's what we're waiting on. So today's the second. It starts next week. And that's it. She's had a very last minute defense attorney come in. Hold on. Another channel read her whole behavior. Oh my God. I bet that's fascinating. I'll have to check the things that have come up today and see if it's in there. Um, I will, or no, I'm sorry. Last minute defense has come back or taken on her case or helping her with it. And so they're doing all these last minute motions, throwing everything they can at the wall to see what sticks. I get it. Um, my guess is this, and again, if you're new to my channel, understand I'm not a doctor, I'm not a lawyer, I'm not a therapist, I'm not a shrink, I'm not any of that stuff. So these are all literally just opinions, right? From watching true crime and, all that kind of stuff. My guess is that her attorney, for whatever reason, obviously wants to work in the case, and he is also, how does he say it? Probably doing whatever Sarah says. That's my guess. Oh, thanks, Chrissy. Holly says seeing her done up in a skirt's gonna be weird. I mean, hey, Ultra, how's it going? And Jenny, if you're out there listening, how are you? I hope y'all are well. I got side note. I got emails. CrimeCon UK just happened, so they sent a thing out like, hey, whatever when they do. And then they're starting to send out stuff for Denver next year. Y'all, I'm already excited about Denver next year. And it's like towards, I forget when it is, but it's like way next year. It's a while away, right? But I'm so excited to hang out with y'all again. We had so much fun. I got to meet Audra and Jenny and obviously Emily and other people and Shayna at the one last year. It was so much fun. Um, so that's what we're doing here. So we're just kind of waiting on this all to come to fruition. Her attorney, I believe, is doing whatever she says. So I think that's why some of the stuff that's, oh, here we go. This seems obvious. Oh God, here we go. Here we go. Okay, here we go. Here we go. Y'all, if she comes out in a ball gown, y'all, I'm hitting the floor. I'm hitting the floor. Well, where'd she go? The courtroom's very empty. I don't think she's coming out yet. I don't know what's going on with that. 3:15. We're just gonna leave it. We're gonna leave the volume kind of going in the background. Oh, thanks, Alexandra, and thanks, Lorraine. We're gonna leave the thing going in the background so we can hear it. Please, Sarah wants professional hair and makeup, right? You know she is. You know she is. Hey, Kathleen, how's it going? RJB says probably died when I saw those gowns. She popped up and Sarah. I know. Can't you see her in a full Loretta Lynn gown coming out? Yeah, when it comes up, Angela, when it comes up, I'm gonna switch it off to where that screen's the bigger one. For sure. Yeah, I think that. Yeah, I think she's. I can. I just think it's gonna give 80s. You know what I'm saying? Shoulder pads, power, pantsuit kind of vibe, right? That's the vibe I think that is gonna happen. So, oh wait, let's see what it says on the thing. Hold on. The Bible community guidelines, no politics, no. Oh, that's the thing for what do you call it? The live chat for Court TV, I guess. Okay. So for those just joining, you have not missed anything. The trial, the case, I'm sorry, the hearing has not started. I can't spit it out, right? We're just still waiting. It's running 15 minutes behind. I don't know if we have a hair and makeup emergency in the back. I don't know. We very well could. We'll see. Oh, thanks, Maggie. I appreciate it. Yeah, Loretta Lynn is if you're into country music or not, she's I mean, country royalty, country music royalty, as far as I'm concerned. She has passed, but this is like, she was older when she passed, but she was pretty much a legend in the country music. But she was also very known for her. She would wear mega ball gowns, like these huge done up gowns and stuff like that. And I'm thinking Sarah might serve some of the same energy. Yep, coal miner's daughter. I'm proud to be a coal miner's daughter. She would do. That movie was so good, y'all. That movie was so good. Oh, thanks, Amy. I appreciate it. Look at them putting the cop on blast and putting his thing on. Oh, I hope Jenny's okay. Let her know that we're thinking about her and sending her love. Yeah, I'm thinking 80s like glam eyeshadow on Sarah. Yeah, y'all, it has been such a heavy week on multiple levels. So this is so nice to do a live chat. When I was sitting here on the couch watching Hidden True Crime, and then I saw the thing, and I was like, wait, that's right, Sarah has a hearing today, and it's actually happening. I was like, oh, we're here, right? Yes, Shanna says designing women vibes. That's 100% what I'm thinking. Wasn't that a good show? You know what? Matt and I have literally been binging over and over Mama's Family reruns, and I'm talking like when we get to the end of it, we just start back over again. Y'all, I love that show. Vicki Lawrence is so funny. Okay, so now another thing, every day I keep going to like I need to do a follow up P Diddy video. Y'all, so much comes out every day. I don't even know where to begin. I don't even know where to begin. I'm just like I don't even know what to do about it. You know what I'm saying? So I'm just like, you know what? At some point, I'm just collecting the articles that I think are of interest. And now I'm gonna make a video on it at one point. It's so much to go over. It's crazy. Yeah, Oh my, so funny. Yep, Golden Girls, Mama's Family, Design and Women. I mean, all the Jeffersons, yes. Oh my God. Okay, so Jeffersons, like that whole, like these are the childhood sitcoms that I grew up with. The ones I just listed off, obviously. Cosby's, what were the ones, the spinoff? What was that name of that where Denise went to college? Y'all know what I'm talking about? Uh, Different Strokes, Roseanne, yes. Good Times, Three's Company. Y'all, the guy, what's his name from Three's Company? His son is on TikTok, and it is bizarre because it's like you're watching a ghost. It's so weird. Hey, Tori, how's it going? Different World, thank you. All the Growing Pains, 227, yes. Family Matters, yes. Different World, yes. Oh, thank you, Chrissy. I know, right. And Sanford and Son, yes. Oh God, here we go. Okay, okay, okay. It's gonna come up as big, the screen big in a second. She's riding. She's got a letter to write. Aaron, no, if you're just joining, it's literally just starting. So unless you just want to hear all the stuff we talk about beforehand, we're just now starting the hearing. Her hair looks worse. It does, doesn't it? She just woke up. She just woke up. Yeah, she's checking for fans, CM says. Her hair definitely grows out with that. You know what I'm saying? She had no idea she had court until 5 minutes. That is so true. She's going to be bitching about that. 100%. She is going to slap her hand down on the counter over that. Y'all, what if she came out with some prison extensions, with some jailhouse extension, and they were just like the cords from a mop tied in her hair? They had dyed with like some coffee. Okay, here we go. They're not seeing anything yet. She's looking over at that table like, I'm going to get you. She has worn this man out. You know she has. Book Mama says, holy cow, short hair, high maintenance. Girl, amen. Okay, I used to work in a salon, not as a hairdresser, but as like the shampoo boy, book boy, all that type of stuff. It's amazing how, yeah, short hair is way more maintenance. Great look when done right, more maintenance. I think shorter hair, male or female, just shows more. It shows more. You know what I'm saying? Her lawyer's over there on Glassdoor looking up other jobs, talking about what are the reviews. He's over there talking to the judge like, y'all got any like receptionist jobs in this courtroom? y'all y'all need anybody like answering the phone or anything like that? What kind of benefits y'all giving out in the courthouse? What kind of 401k y'all offering in courtroom 403? He's like, I could do some janitorial work after the day's done for a little extra spending money. Scrape by. Oh my gosh, right? Okay, they're not saying anything yet that I can tell. Hey, what you doing? She's got this poor man. He doesn't know which way direction. I feel bad for him. I mean, he knew what he signed up for, but it's just, I just. Aaron says, Aaron E says, no hair and makeup day. That motion needs to be approved first. If they approve that motion first and she pulls some damn Skittles out of her little pocket and starts making herself up, I am locking off and I am done with YouTube. If she starts making herself up at the table with some Skittles, I'm done. Hey Mimi, how's it going? Oh, I mean, what are we doing here? She's smiling. Tori says, "Don't be ridiculous, Paul. We all know M&M's release color better. This is true. I mean, I guess. I mean, what? So it's three. I mean, I know it doesn't start on time or whatever. You know, I'd never noticed a thing about the glasses either. That is interesting. That looks very uncomfortable. See how the lawyer has the glasses resting like on his head, not on his ear? Ear? Thanks, Melody says patience, Paul. We'll get good soon. Yeah, frazzled is a good word. She's over there just reading through the thing. Again, I think that he's just doing what she's like, I want you to do a motion for this. Okay, that's what we'll do. Because if you read some of the stuff that the state comes back with, they're like, I don't know why they're doing this. Almost like he hasn't cited this or that. I think some of the stuff there is nothing other than her just wanting to take a shot in the dark. You know what I'm saying? And so that's where they're at. And that's why a lot of these other attorneys were like, absolutely not. We're not going to do that. Thank you, Pauline. I mean, we're still just kind of. So for those joining, nothing has happened yet. She is obviously at the table. Obviously, his lawyer's there. They're waiting. I guess I don't know what we're waiting on. Um, she's kind of chuckling. She's reading the stuff. She probably thinks that she ate. Oh, thank you, Emily. Indie Girl 57. What's up? Hey, Indie Girl, if you get a chance, drop me an email or Emily. My email is reporting live from my sofa at gmail.com. Tori, one more hour and I can go home to my dark house. Which I'll pay that. Oh, he's got a lot of whiskey. Oh, he's just going home like, oh my gosh. Oh, thank you, Pauline. I appreciate it. Pauline gifted 5 membership. Bum 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 bum. Yeah, let's get some of these little emojis going. So we got some gavels going. We got a little cough. We got to definitely roll our eyes hard enough up in here. We might need to give her a little zap over there too. Hey, school, how's it going? Feeding it. It was not a good show. So speaking of TV shows, the Feeding It TV show, A Team was good. A Team, MacGyver. So these are like I call them my boy TV shows. MacGyver, A Team, GI Joe, He Man. What else was like that? Cops. My dad used to watch that all the time. Star Trek. V, if you remember that. Yeah, we're just kind of Quantum Leap was so good. Twilight Zone. Amazing stories. For those just joining, you have not missed anything. All they've brought her out finally, and they're just sitting there. I think she's looking over her glam squad motion and just counting down the minutes till she can get professional glam in there. Um, Scarecrow is. Oh, I didn't see that one that much, but I know what you're talking about. Hawaii 5 is. Oh, Thundercats, yes. Sailor Moon. I didn't get to. I never saw that one. MASH. Oh my God. Okay, when I was growing, that's one of my first memories of a TV show was MASH. My parents would watch it, and I thought it was like real. You know what I'm saying? Like when you're a kid, you don't really know the difference between whatever. Like I thought that was like real, so I thought it was like real, like dead serious when that show came on because it was like, oh my God, like this is happening. Like, and you know how like your perception is just weird as a kid, and you're like, that's happening somewhere in North Carolina or whatever. On Ableist's pod, do you get my email about? Oh, yeah. Okay, I think I did Ableist. I'm gonna go back and look at email. I've been basically incognito. I'll double check today though. So, and I apologize if I haven't gotten back to you or anybody or whatever. I've just been kind of like in puppy dog land and whatnot. Watch Mass every day after school. TV was more real back then. It was. TV was way more real, right? Okay, y'all. Do y'all hear that?
Now, Gork, I'm ready when you are.
Okay, drop a one if you can hear them talking. Knight Rider, yes.
Need to catch Trump half the state.
William J. for the state.
James Owens for Sarah Boone.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-77.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion?
Yes, Your Honor.
Are you ready to proceed on that today?
Yes, Your Honor.
Okay, are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yes.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or
Yeah, if you look
Huh?
in the very back, you look in the very back,
Okay.
you see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can leave?
Yes. I also have reviewed the 2-hour and 6-minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification is a DVD, courtesy copy, body worn camera.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection?
What was pre-marked as States A will be received into evidence without objection as States 1.
This is painful.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Kessel, Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes,
And each of the third weeks you will be on call?
yes,
And then through some other random distribution, it's determined who of the 4 will be the lead?
correct.
And it was your turn to investigate the death of Jorge Torres?
Yes,
And you were notified of this on February 24th of 2020 in the afternoon?
yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Scott Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it was more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes,
I do, yeah, like business professional.
like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else, and then once that was executed, we went in there further with CSIs, and then we talked to Brian Boone, which was the ex-husband, and then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color, didn't look like, it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
Okay. At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but yeah, she was able to leave.
Prior to that, had she been detained and requested not to leave the scene?
One more time?
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potentially child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then, if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
In the second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms?
We have 4 interview rooms that are audio and video recorded.
Okay, and they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the Sheriff's Office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
And while you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right, and at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form, Sarah, give me the password to your phone?
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right, you're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
is when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview, yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived?
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time, what is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car? Or
Yeah.
standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're gonna go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But
Okay.
I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because it's the policy of her department.
But
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights to remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. Well, you can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
I'm sorry?
It's not on my Miranda card that I read from. But you can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the, in reference to the policy, yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back?
No,
You did not tell her that?
no. I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines, yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence?
Standing next to me.
Okay. And did y'all discuss that issue?
Objection, relevance. relevance, work product.
Sustained.
Okay. At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know off the top of my
Okay.
head.
And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes,
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lone was with me or not, but yes, of course, there's doctors there.
Okay. And so, in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect, they had probable
What does that
cause.
have to do with any of the 3 issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first.
Okay.
The objection is sustained.
Okay,
You may proceed.
all right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to
Okay.
leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway?
Correct.
And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance. As to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th?
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the video, the 2 videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time?
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
Now, you've said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, "I'm going to have you sit in the green chair"?
Objection, best evidence is the recording.
He's right.
Okay,
Objection sustained.
okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, improper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection to relevance.
Overruled.
I did not ask for question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
You may.
See if you recognize that document.
Yes, this is our waivers and affidavits.
Is that a filled out waivers and affidavits form?
It's filled out by me, but there's something highlighted that I did not do.
Okay. And was that form filled out as it relates to Sarah Boone?
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or not?
Yes.
Did you see her sign it?
Yes.
Is that your signature below?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda ordinance?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, no.
Okay, you would agree that there's 9 questions on that one? No?
Yes.
Judge, would like to offer this.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Good response.
Judge, obviously, we disagree,
Well, then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
The
Judge.
right to remain silent, the right to an attorney before and after questioning. If you can't afford one, one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
No. Y'all, this cannot be happening.
or when you read her Miranda in the squad
Here we
car?
go.
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay. That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. All right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the card.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. Just that one.
What is it that's been marked as Defense Exhibit B?
Judge, it's the-
Any objection?
Same objection, it's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same argument as I've made.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously. And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge, it's the policy of the Sheriff's Department. And, it's a general
Do you know what page specifically those policies are on?
Page 14 of 22. And I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes?
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
Oh my God, y'all, this is like Christmas. I cannot.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
Y'all, I cannot believe this. I am dying right now. Oh, she is steaming. Okay, I'm going to be quiet now. Here we go.
Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Objection,
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes,
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No,
Did they ever indicate to you that you were a person of interest?
no,
Did they ever refer to the videos that you recorded on your phone from the night before?
no,
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time,
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesall?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Hopesall told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesall's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes,
And did you talk to her?
yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Irrelevant what her statement is.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know what's pending and how to object to it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car, and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No,
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
no,
Okay. So directly off the elevator and walked into the interrogation room?
correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes,
You recall that happening?
yes,
Did that refresh your memory watching the video?
yes.
Do you recall her saying that she had received the autopsy?
Yes,
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
And she also said, we're not done talking about the incident. You recall that? And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you, do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone, did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, she's in custody.
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial
Okay,
interrogation.
but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to
she was
whether or
being
not-
Let me finish. She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Objection, relevant.
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Objection, relevant.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent, and I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what it was.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the.
I would object to that. I'm not understanding what the question.
Mr. J?
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to council's table. While she's in the process of returning to council's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Wow, y'all, this is good.
Mr. Owens, it's your motion, sir. You may proceed.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand, I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned, Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's, and of course she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, there's 2 exhibits that I tried to introduce. They will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, just a clarification, but, you know, she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over
No,
here?
that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other two lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny, and she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here?
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay.
Beliefs.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial, just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed, can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting at 9 o'clock every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Judge, and then I think there's something about hair as well.
I think that it falls under the same
Okay.
analysis.
Needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, oh, I'm sorry, yes. Yes. So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see,
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the, and listing the, I think it was the,
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their requests, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That,
How would that not be protected by work product?
well,
As to whether or
if
not it was a
if it comes
decision.
out, if it comes out that she went down there and requested the charges be dropped, and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it, and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow?
Yeah.
And that will be done virtually?
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion to eliminate.
Okay, all right, appreciate it. All right, thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all. Which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right, thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
Well, well, well. Now let's see how her grand exit is before we start talking about all this hot mess that we've just witnessed. She's over there like, you're gonna have to wait. Yeah, bailiff is over her. Okay. Wait, is that it? Okay, so. There we go. That's it. Ooh, y'all. I was not expecting any of that. My mouth is on the ground, okay? I mean on... Oh, what's this? Wait, hold on. Where's this coming from? Where's this coming from? Where's this coming? Oh. I was like, what? Wait, hold on one second. Let me do this. Copy. Boom. And then boom. And then boom. Please hold. Please hold. Please hold. Please hold. Bum, ba-dum, bum. Bum, bum, bum. So, yeah, I wasn't expecting any of that, y'all, at all. I'm shocked that we got to see that. I'm not really speechless because it honestly went the way that I thought it was going to go. I'm curious to see what y'all think. Pardon me. I mean, it's just, I get what he's trying to say and he's trying to pick it apart. I totally understand that. But the fact that he's latched onto number 9 or whatever it was being read, if we're talking about the Miranda thing, it's just... It's gone. If they didn't read any, if like the Miranda was completely left out of everything and they never read it to her, I would 100% be more like, they might have an argument going here, right? But it's this like little nitpicky thing. And again, when you watch the stuff, it's like she knew what was going on. Now, this whole dynamic of, oh, you know, they lied to get her in there and she didn't know she was going to be under arrest and this and the other. Again, they had to, in my opinion, of course, I'm not a legal expert by any means, but it's like, well, by then they had looked at the evidence and the evidence speaks for itself. You know, of course they were going to arrest her at that point, right? Now, this whole thing too about the phone call with the detective that night, here's my thing. Let's say the detective's lying. Like, she knows that Sarah called her and said all that type of stuff, but she's just going to lie because she knows there's no proof of it. Okay, again, Sarah, I would rather leave that out if I was Sarah than to admit, yeah, I called him and said, I think you're trying to trick me. Why would you call them and say that? Why would you call them and say that? You know what I mean? And now trying to get up there talking about, oh, I was drunk, I was this, I was that. I mean, here's the thing. When they get her on the stand, and they've been giving her warning shots of what evidence is going to come up, pardon me, on the stand, and it's y'all, this is gonna be, our mouths are gonna be on the floor, I think, when we're watching this case, okay, when the trial, I'm sorry, I think our mouths are gonna be on the floor as to the things that are coming out that they have totally warned her about, like that stuff we just heard about the DV and all this type of stuff, and it's like they're trying to make a case. But again, I just, after seeing today, I absolutely think that Owen is just literally going down a list, and he is doing whatever she says, and he is like fighting tooth and nail on something that I would pray he knows isn't going to work, right? Because he's clearly been an attorney for a long time, so it's like to get to this point, pardon me, of his career and be arguing some of the stuff that he's doing in the way, I'm just like, surely no. And now the other part too, where he was talking about the impeachable part, okay, I'm just kind of throwing up all the stuff in my mind right now. So when he was talking about that impeachable part, you know, she was up there just like, you know, I'm gonna kill him, you know what I'm saying? Because like a lot of the stuff that he'll put up, and I don't think she realizes this, or that he'll say like, well, yes, I agree, or he does this also, where he's like, I think that they're going to say this, and then he'll say like the worst things possible, which is probably what they're going to say. And it's like, Sarah does not realize, she doesn't hear the same thing, where it's like, yeah, they're probably going to say that, and yeah, that makes sense. You know what I'm saying? The detective up there in the stand, yes, let's all drop dead gorgeous, right? The blowout, the lipstick, the makeup, the I'm unbothered by this, you know, the whole thing. Yeah, I just want to read some of your comments. I can't believe that she took the stand. If you're just joining, you need to stay and watch the whole thing. Go, Sarah takes the stand later in the video, and your mouth will be on the floor. Okay, your mouth will be on the floor. I mean, they're just all over this. I mean, we just literally listened to what? About probably about 2 hours worth of them going over this Miranda thing. You know, and again, listening to the judge try and break it down to Owen, where he's like, and I don't remember now, I'm just going off the top of my head, of this whole not reading number 9 or 10 or whatever it was, only reading 9 of them, there's 10, whatever it was, over and over and over and over, and we ask it in 20 different ways. Y'all, this just gives you insight into how she works. Now, you got to hand it to Sarah. Regardless of how she has dragged this out for 5 years. 5 years she has played this game and dragged and played this game with all of them and been able to do this. Imagine what she was like at home. Somebody's awake. Somebody's awake. Imagine what she was like at home. Oh yeah, and the voice she was using. I was up there. Remember, I was afraid. I was kidnapped. He had a gun! That part where he keeps saying, like, the officer had a gun. And I'm like, yeah, he's at the police station. He's a cop. Of course he has a weapon on. I think, don't they all wear those around the station that are supposed to be wearing them around the station? You know what I'm saying? I'm just like, it's so funny to look at the things. I mean, there's literally only straws to grasp at with this, right? And again, like some of the arguments, like the Miranda thing, again, I'll say this 100 times, absolutely. If they didn't read those Miranda rights at all, I'd be like, y'all, we might be looking at them getting ready to throw this out. Smog said, did I miss the motion request to carry in her ball country? Yeah, Smog, you have to go back and listen to the very last part for the Glam Squad. I'm thinking, okay, first of all, let's just talk about the petty stuff real quick. Y'all, the fact that the judge is basically like, you have to do her glam in open court, 100% that was for us, y'all. He heard our cries and he served. He was like, I'm going to give the people what they want. I'm giving the people, this is the people's court. I'm giving them this one. You got to do Glam Squad out in open court before you get started. Secondly, imagine if the Owens is like going to get someone on my team. Y'all, what if they get like say they have a drag queen working up in there or something like that, like some like whatever, and he's like, oh yeah, I'll do her makeup. And he sends her out there in full drag queen makeup with her prom dress on. I mean, can you imagine? Or if somebody who absolutely has no clue how to do the makeup or whatever, she turns around and she's got like red lipstick looking like the damn Joker. Just like neon blue, just white over her eyes. Damn, Curl and Iron burnt her notes up on the table. Oh my God, y'all. Oh my God. They should. Yeah, what if the bailiff had been like, I'll do her makeup for her? Oh God, y'all. Y'all. I really have never seen a case like. I mean, it's almost like it's made for TV. Like I'm waiting for the end of it. You know that TV show that came out where it was like the person on the jury found out that they were actually in a TV show, and everybody else is like part of the show. I'm waiting for that to happen with this, where it's like we've been punked. This never happened, and like we, the audience, have been like walked through it. You know what I'm saying? Oh my gosh. I cannot. I mean, this is the most insane thing I've ever seen in my life, okay? Oh. Yeah, this is our palate cleanser for Chad's trial, right? I mean, seriously. And why hasn't Lifetime makes cases or movies about these cases like before they even happen? This has Lifetime. Even Lifetime might be like, no, this is too much of a circus for our stuff is a little bit more serious. This is a little bit too over the top. I mean, honestly. Oh my gosh. Y'all. I'm literally in shock that she took the stand. When they said get her on the stand, I was like, what did we do to deserve this? I mean, I was just like, are you kidding me? Oh, man, I needed that. I needed that so much. Come on, what you doing? What you doing? Come on, over here. We don't need to. Oh, y'all. Yeah, so what I'm going to do now, obviously, is I'm going to go back over it and make a video for the main channel. And I'll probably just focus on Sarah's testimony. I mean, that's the main thing. Because all that back and forth we just suffered through with the Miranda thing. Yeah, hey, come here. What are you doing? We don't need to jump over there. Look. Say bouncy, yay! Somebody's awake. Somebody's awake. Yes, he's actually been really good for the whole hearing. I know. He's like it's a mega playtime. Yeah, but the whole thing, I think the biggest part of that was the her getting up on the stand. Obviously, in the beginning, good boy. He went on his little pee-pee pad, so we have to make sure we say good boy as he's doing it. So when the detective got up there, that was good too, right? To finally hear from her, because last time we saw from her, she was coughing and pregnant and sitting in a cramped up room with Sarah. You know what I'm saying? So So yeah, so this is so if you're just joining, number one, you're going to want to watch the whole thing because Sarah takes the stand. Number two, there's some kind of a court holiday tomorrow, but it's like the court's working, so it sounds like they're just not going to be like doing hearings. But he did say he's going to come up with some kind of ruling. I mean, correct me if I'm wrong. So we'll be looking at the thing, the where they post all the paperwork and whatnot. I mean, 100%. So this is my take on it. He's not going to grant the thing about the Miranda thing, right? I mean, come on. Um, so Tori, you have to go back and watch it. Sarah took the stand. You absolutely have to go back and watch it. Um, I don't think he's going to grant the thing about the Miranda or any of that. Again, they know, meaning the defense, that was their moment to shine. Okay, if he could get that thrown out, it would be a huge benefit. So he knew he had to really go up there. Also, what this tells me is that this is clearly is something she has probably harped on with these other attorneys, right? Is that part because he's just going on and dissecting it and dissecting it, and I am sure it is coming from her that she has latched onto that last question, and that her other attorneys were probably like, it's not going to work, and he's the first one that's like, you know what, we'll go for it. We'll just go down the list. You know what I'm saying? So, and then the very end part, yeah, Emily says she'll be. Did you say, wait, let me see, she'll be shackled? Yeah, I mean, he's going over stuff that's already been settled. And I think some of it is just exhausting to the court, the judge, the state attorney. It's like, we've gone over this, we've gone over this, we've gone over this. You know what I'm saying? And here we are, days before a trial starts. Um, so here we go. So, yeah, wow. I am just. This is going to be great. So she's taking the stand. And here's the thing, too. He already explained to her they're going to impeach her because she's trying to talk about. Let me gather my thoughts. So many are going on. Okay, so they're like, we're going to impeach you if you do this whole I was drunk thing, and adding more information and all this type of stuff. So she's aware of that. But this is what she does. When she was sitting there talking about, when he was like, were you impaired or whatever, and she didn't want to answer. I mean, literally, I think she's trying to figure out the best way to answer in her favor. Of course, who wouldn't, right? I get that. But the fact that she's trying to slide this stuff in, I'm telling you, she's going to do it in open court in front of a jury, and it is going to make them get up there and absolutely decimate her on the stand. It's going to happen anyways because she is convinced, I mean, we've seen this today, that she is going to get up there and talk her way out of this. That she is going to get up there and talk her way out of this. Like the whole thing about this, I didn't know why I was talking to them and whatnot. It's like you had a list of stuff that you pulled out of your purse right away. You knew you wanted to talk to them when you went in. Well, excuse me, mister. And excuse me. You know what I'm saying? It's like you knew you wanted to talk to them when you went in. Again, she's going to get, this is my prediction. I mean, I cannot wait for this. She is going to get up there and she is going to absolutely say something that they are going to put her on Front Street, even if she didn't. Okay? You can't get around the video. Listen to all the stuff they're talking about. She recorded on the phone. I mean, what was this woman doing? Live streaming her life? What the stuff she's recording? I'm like, why would you record this? Why would you record? What didn't you record? You know what I'm saying? Like, why would you put this stuff? But maybe she was drunk all the time and didn't know she was recording it. Maybe that's like, maybe she had this thing with getting drunk and like recording her criminal acts. I mean, I don't know. You know what I'm saying? But like all the stuff that they're bringing up, it's like, why? Like, what? Let this be testament. Let this be testament, okay? The phone thing, yeah, the detective is gorgeous. I mean, she is stunning. I was like, oh my God. And the way she just sat up there, like, completely unbothered. Oh my gosh. I'm just kind of reading through some comments and whatnot. The way she said that she was like drunk. Okay, so the drinking thing, when she was like, I was drinking, still drunk from the night before. It's like what, 1 o'clock in the afternoon that she's talking about. Hey, there you go. Hold on. Yeah, he's gonna have the paralegals do her makeup. Yeah, the Miranda issue was that. I mean, that went on forever. And again, if the cops had never read that to her, I would completely understand. Like, of course you would. This would be a huge issue, right? I know, right? Sharon says, I hope they get the mic fixed before the trial. I mean, seriously. Oh my gosh. Oh my gosh. I mean, for real. I think they still have a couple of little things to do. My guess is we're going to see major activity every day leading up till Monday. What is today? Wednesday? Is today Wednesday or Tuesday? Today's Wednesday. Okay. Everything's blurry. I think Brian Boone's going to get up there and testify. Again, they've warned her all along of the stuff that they're going to get up there and say. I mean, it's, again, at a certain point, it's just like, what? The judge is going to, if she is found guilty, the judge is going to have to absolutely force a non-smile on his face when he sentences her. He's going to love every second of it. Oh, right. And SD says the jail staff must be exhausted. You know it. You know they are all so tired of her and her story. Because she's going back to think that's all she's doing is talk just about it. What you got? Oh, I know. I'm just reading your things. Yeah, this is just wild. So wow. So here's what we're going to do. So I'm going to go do puppy time, puppy feeding time, all the fun things. And then I'll work on the video for the main channel tomorrow. And I'll rewatch it with some more different thoughts and whatnot. Hopefully I can have it up by the morning, but we'll see. And then we'll just be on the lookout tomorrow because you know that there's going to be, I mean, you heard the judge, he's going to rule on this stuff. So we'll kind of be on the lookout for that. And we'll see what pops off. So there is that. Y'all, thank you so much for joining and hanging out. This was so amazing. Oh my gosh. Oh yeah, let me get Puppy. Come here. Luke, come here. He's like, what's going on? I know. This is Mr. Luke. Well, see, hey. Yes. It's food and crate training time. And obviously playtime. But thank you all. Thank you, Emily, for holding it down. Pardon me. Thank you, everybody, for membership, super chats, for the conversation, for keeping it going and light and cool and respectful and all the things. I do appreciate y'all. This was so much fun. Be on the lookout for tomorrow. And we, depending on what happens, we might do live tomorrow. We might not. We'll just kind of see how the day unfolds. But that's it. I love y'all. Y'all take care. I'm going to be doing my review on The Substance. So look for that this week because I saw it and yikes. I literally need to trauma bond over that. But that's it. I love you guys. I'll talk to you soon. Y'all take care.